A large part of my practice is defending consumers who have been sued by debt collectors or debt buyers. And what we find often that happens is that a consumer will get sued and they go, wait a minute, I know I don't owe this debt, so I'm not going to do anything. I'm going to ignore it. And then they get a default judgment. If you're sued in district court, 14 days to answer. Circuit court, 30 days to answer. And if you go beyond that time, these collection lawyers are very, very good. They will, sometimes the very next day, they file a request for a default judgment. So then time goes by, maybe a year, 2 years, 3 years, 5 years. And consumer says, hey, nothing's happened, no big deal. And then suddenly this judgment has grown tremendously. Suddenly your bank account's wiped out. Suddenly your payroll department comes to you and says, look, I've got a garnishment order here. And so what happens is we'll sit down with folks and they'll say, but you don't understand. I don't owe this debt. I go, well, it's been too long. There's a certain period of time you have to challenge a default judgment when you've been served. And people say, but this is a travesty of justice. I hear you. But in our court system, there has to be some finality of judgment. In other words, if you win, we don't want the debt collector coming back 2 years later and saying, yeah, but the consumer really does owe this debt. And we deal with this all the time because we sue these debt collectors in federal court, and they come in and they go, but judge, it's just not fair because the consumer really does owe the debt. And the federal judge looks at the order and says, nope, looks like the consumer won. We're not revisiting that issue. And if that wasn't the rule, there would never be any final judgment. It would just be everybody goes to a different judge when they're unhappy. And we'd never resolve controversies. So if you've been served and there's a default judgment, you have a very limited amount of time to get that taken care of. And so I realize that if you're in this situation watching this video, it may very well be too late for you. Check out, talk to a lawyer that does this type of work and see if it's too late. But I suppose what I'm really trying to accomplish in this video is if you've been sued and you're wondering, maybe you read on some internet site a message board that said, look, if you don't owe the debt, then that judgment's meaningless. Well, even though I have a lot of people tell me you can't collect debts in Alabama and debt buyers can't sue, unfortunately, those aren't judges that say that. Those are people who think they know what they're talking about and they really don't. The truth of the matter is, if you lose your case in Alabama, then you owe the money. And it really doesn't matter if you know in your own head, hey, I don't owe this money. Because what truly matters is what does the judge say. So if you've been sued, take it very seriously. A default judgment messes up your credit report, 12% interest a year. It means in 6 years it doubles. So 12 years, it doubles again. $5,000 judgment, 6 years, $10,000. 6 more years, $20,000. 6 more years, $40,000. That's the power of compound interest. So very serious consequences. Take this stuff seriously. If you're going to do it yourself, then do it yourself. If you're going to get with a lawyer, then get with a lawyer. But whatever you do, don't wait. Don't let a default judgment. If you do that, the collector wins, even when you don't owe the money. So I hope this has been encouraging to encourage you to take action. If you live in Alabama, and that's who this video is directed for, and you want to talk with us, that's fine. 205-879-2447. My name is John Watts. You can call other lawyers in Alabama. If you're watching this from another state, get with a lawyer in your state. But make sure you do something and avoid that default judgment. Thank you very much.